Good afternoon. So my name is Karen Harding and I'm a criminal defence lawyer from Auckland, New Zealand, and with me today is Peter Eastwood Barrister of Auckland, and we've invited him to come today to give us a
Short talk. 7 minutes.
About
Fake law.
which is this book.
Yeah.
Fake Law, The Truth About Justice in an Age of Lies, The Secret Barrister,
Yeah.
an award-winning bestseller
Yeah.
from a barrister in the UK who wishes to remain nameless. Shall I just read the back blog to the people so they can
Okay, give it
get the idea of it?
Yep.
Most of us think the law is only relevant to criminals, if we even think of it at all. But the law touches every area of our lives, from the intimate family matters to the biggest issues in society. Our unfamiliarity is dangerous because it makes us vulnerable to media spin, political lies, and a kind of misinformation that frequently comes from loudmouths, amateurs, and those with vested interests. This fake law allows the powerful and the ignorant to corrupt justice without our knowledge. Worse, risking to make us complicit. Thankfully, the secret barrister is back to reveal the stupidity, malice and incompetence behind many of the biggest legal stories in recent years. In Fake Law, the secret barrister debunks the lies and builds a defence against the abuse of our law, our rights and our democracy that is as entertaining as it is vital. That sounds like it's written by another unknown person.
Yeah, well, we've all heard about fake news. So this enterprising lawyer in England who remains nameless, maybe for good reason, has written a book about what he calls fake law, which is kind of interesting. So what is fake law? I think he's trying to say that that there's a problem with the media and the powerful, is that they will set up a false narrative about what happens in the law so that people become indignant and outraged. I suppose they're thinking about the popular press like The Sun, News of the World, Daily Mail, which tend to be celebrity driven and generally to the right of centre. So a good example is let's deal with a criminal situation, is a scenario where there's a case he refers to here, a man got convicted, a well-known soccer player got convicted of rape. He took it on appeal, and the Court of Appeal allowed the appeal, dismissed it, acquitted him. Now, there was a big banner headlines from his PR people say, my innocence has now been established. What the writer's saying is that's not entirely true. And yet, so people are saying, "Oh, well, I'm innocent." And apparently, he was PR people that pursued the complainant to say, "Well, she's obviously a liar," and all the rest of it. But what the barrister says is that's not in fact true. What the court did say is that, having reviewed the evidence, I mean, a jury may well have been unsure, or there shouldn't have been a finding of guilt. So that's not that he's innocent. It's just the truth of the matter is he hasn't vindicated him and proved his innocence. Quite the contrary. So everyone's saying, "Look, I'm an innocent man," and they're full of outrage and indignation. But in fact, they haven't established his innocence. All the Court of Appeal has said is that we're not entirely satisfied you're guilty. So that's an example of how the media manipulates and powerful interests manipulate the media to sort of denigrate the law and make it look like it's, manipulate for their own purpose.
What about the presumption of innocence? Like, you're presumed innocent until proven guilty.
Well,
in that case, he wasn't proven guilty because
that's right,
there were doubts about it.
But he's not innocent. But what they're saying is,
he's not guilty either, is he?
My innocence has now been established. This writer says, well, his innocence hasn't been. He hasn't established his innocence. It's just established that he's not guilty, and there is a difference. That's all we're saying.
Isn't that the reflection of the justice system, that the justice system doesn't always get to the truth of anything. It's just a system. It's not necessarily justice, because it's really just the legal.
Yeah, well, some would say it's
system.
often two competing narratives, and which one is more persuasive to the jury.
But otherwise, say the fellow didn't actually do it, then he could never prove himself, because that standard of trying to prove your innocence is too high.
He doesn't need to prove his innocence.
No.
There's no duty on him.
But you're saying that he can't even say, look, I'm innocent and I've been vindicated.
Well, he said his innocence has been established. You can say he's innocent, but the Court of Appeal didn't establish that he was... anyway, this argument.
Yeah.
There is a subtle difference, I was saying that. And again, there was
They have the Innocence Project in the United States, don't they?
Yeah.
Well, Victoria University has one as well, to help get the people off death row when they hadn't had the old DNA evidence in the old days.
What he's saying is that it's just that the manipulation by the media and powerful interests of the courts. Again,
maybe need a better example.
The DPP said she made the observation not every acquittal represents a false complaint, and there was outrage at that, but the public.
But then you could not be sure, which means you've got a reasonable doubt, because you can't be sure.
And that's right, but she probably should. In some ways, maybe they were a bit too hard on her, because it's not necessarily a false complaint. Often the complaint has some foundation in fact. It's just it wasn't quite the way it had been expressed, or there were circumstances around it that made a court or jury unsure. There's another example here of a guy in indecent assault. 10 allegations of indecent assault. Said, I've been vindicated. And again, this writer says, well, no, you haven't, mate. Not entirely. I mean, what?
He'll never be able to be vindicated. Then he could get found.
He wasn't vindicated.
Guilty.
He was.
You get not guilty, and you just got mud spread all over your reputation. You can't unclean your mud.
Yeah, I know, but he's saying that when he said he's been vindicated of 10, this writer, barrister says, and a lot of old barristers been around would say, well, with 10 allegations, there may well be some foundation in irregular behaviour that supports this, supported the prosecution, and it may not have been entirely false, the complaints. There may have been some foundation. It just didn't satisfy the requisite standard. So that's his argument.
Well, that's it. But I don't think that makes anything fake if it doesn't set the standard of beyond reasonable doubt. Because otherwise you get the civil standard, which is on the balance of possibilities. So in a civil case, it's the balance of probabilities. More probable than not that X, Y, Z happen. If you put that into the criminal arena...
Well, he makes a point that, of course...
But the civil people don't go to jail.
Guilty people do get off because of a very high standard. But we shouldn't worry about that too much, because it's better than the other way around, where innocent people are convicted. So that's his premise that underpins his story.
Is there anything else in there?
Again, he talks about how a case about a prosecution of a man for murdering his wife, Broadhurst, and the defence advanced that she died of a mixture of cocktails and also assaults. Anyway, the prosecution tended to accept that her abuse of drugs and alcohol could well have supported her death, and that she had maybe was what participation she did have in being assaulted was because she enjoyed rough sex. There was a lot of indignation about that outcome, but anyway, the court found that it should have been manslaughter rather than murder, and there was a lot of indignation there that this woman was basically, this victim was shortchanged. But he makes the argument that that both the prosecution and the defence both looked at the matter, and they decided that the appropriate verdict, the judge was persuaded the appropriate verdict was one of manslaughter. But not everyone was happy about that. So it's again how the press full of indignation, but he takes the view that that was possibly the right decision, even though a lot of women and women's groups were outraged that a man is clearly, in their view, responsible for a woman's death and has got off on manslaughter. So that's one of the cases he refers to. So those are the sort of way he deals with these cases. And he also talks about personal injury, how the press are often outraged that somebody, got a hot, scolded themselves on a takeaway McDonald's coffee and got tens of thousands of dollars compensation or pounds of compensation, and the press are indignant about the abuse of it. But he makes the argument that some of these cases have merit, but the press, for their own reasons, want to discredit the law, and he said that's unfair.
So, is underlying it this outrage of the press? Perhaps the press is the press is like.
Well, the press has always been
creating an outrage.
Yeah, well, they're conservative.
To sell newspapers. Is that
well, they're conservative. I mean, the politicians know there's no votes in prison reform. A lot of politicians get into Parliament saying they're going to be tough on law and order, and so the media likes to advance that proposition, and so they find a case and say, this is outrageous, this is a guy killed somebody, and he's got off on manslaughter, and it's ridiculous. And all the public agree with him. But this barrister's saying, well, if you analyse it a bit more carefully, maybe there's some merit in the decisions we make.
Well, of course, the judge and the jury have heard all the evidence.
I mean, that's right.
That's
exactly it. It's trial by media. They just make a few sensational remarks,
picking, aren't they?
And they get some victim's family that are outraged and indignant. We have that in New Zealand too. Often families come along and they're full of outrage and indignation that judges have come to a decision about sentence which they think is wholly inadequate. So, I mean, that's the sort of thing he's arguing. He's saying that, well, maybe you should be a bit more, consider the matter a bit more carefully and more moderately, and you'll realise that.
So why does he have to be secret? None of those things are really outrageous.
Well, he's got to be secret.
Is it because he's a lawyer in some of these cases?
I suspect he'd rather not. He has to appear in front of judges. He wants to be robust and independent, and he feels that possibly that if he's well known, it might damage his career or damage his relationship with his clients or damage his relationship with the bench. So there we are. That's wrapping it up. That's a fake law. That's a new spin on what we hear about fake news. There we are.
Fake law by the secret barrister.
Okay, so that's all right.